Welcome to CLE-TV. Today's program is Limited Scope Retainers, Practical Advice and Tips. My name is Meredith Woods. Just before we get started, I want to mention a couple of things. We will be asking for your input throughout the program. We'll ask you several questions that you can participate on the screen with in the poll question period. If we have time at the end of the program, we will also take your questions. But the presenters are, of course, available after the program through their websites and telephones through the Law Society, and we have their contact information on the materials page. Also on the materials page are links to the resources that will be discussed today, and following the course, we will post a PowerPoint that will be reference material for you. The link to the email, the materials page is in the email invitation to the course, and it should also be posted here in chat. I see it's just been put up. Our presenters today are Doug Monroe, Barbara Buchanan, and Margaret George. Doug Monroe is a policy lawyer at the Law Society of British Columbia. He assisted the Unbundling of Legal Services Task Force research and present its report, Limited Retainers, Professionalism and Practice. Doug currently provides legal policy support to the Law Society's Access to Legal Services Advisory Committee and Family Law Task Force. Welcome, Doug.
Thank you, Meredith.
Barbara Buchanan is Practice Advisor, Conduct and Ethics at the Law Society of British Columbia. She provides confidential practice and ethics advice to lawyers in a wide variety of practice situations. Before taking on her practice advice role, Barbara was in private legal practice, was an adjudicator for administrative tribunals, and was general counsel of an international company. She has also taught law courses in a variety of settings in BC and abroad. Welcome, Barbara.
Thank you, Meredith.
Margaret George is the Deputy Director of Insurance with the Lawyers Insurance Fund, the group that manages the Law Society's compulsory professional liability insurance program. As Deputy Director of Insurance, Margaret assists with LIF's management and administration. Margaret left private practice in 1988 to join LIF as claims counsel, and since 1998 has carried additional responsibilities, first as program administrator and more recently as Deputy Director of Insurance. Welcome, Margaret.
Thank you, Meredith.
So this course is about limited scope retainers. In a limited scope retainer, the client retains the lawyer to perform only certain aspects of a legal matter, with the client maintaining responsibility for the remainder. What we're going to talk about today are opportunities you might consider that could expand your client base and help to improve the public's access to legal services, what the code rules are and what the risks are, how you can manage those risks, and what the current research and thinking is. So with that, I'll turn it over to you, Doug.
Thanks so much, Meredith. And thank you all for joining us today. I'm going to start just by pointing out that probably throughout the presentation, we'll use terms unbundling, unbundled legal services, and limited scope retainers, and we're using those all interchangeably. Essentially, what we mean by that is any circumstance where your client retains you to perform a discrete task, and you leave it to them to perform other legal tasks that in a full scope retainer you would normally provide the services for. The Law Society became particularly interested in unbundling as an access to justice issue and tool around 2004, and there were a couple drivers for that. One of them was the rising trend in self-representation before the courts and several particular concerns associated with that phenomenon. One, obviously, was the impact it had on the courts and their processes itself, how judges could carry out their duty as impartial adjudicators when there was one or more self-represented individuals before the court. The Law Society was concerned about the impact the presence of a self-represented litigant would have on the process for other litigants, in particular if they are represented by counsel, and how that can affect things. They're interested in the impact on the potential quality of the outcome for self-representatives when one or more are engaged in litigation, and the development of the common law. And lastly, to the extent that all of those factors can combine to potentially create results that aren't as favorable as they might be if lawyers were there, there's a potential negative impact on the public perception of the administration of justice. So what the Law Society did was it struck a task force. For most of that task force's existence, it was chaired by Carol Hickman, QC, whose life venture now out in New Westminster. And they engaged in fairly extensive research, mostly looking at the situation in unbundling in the United States, which had a bit of a head start on Canada, sort of in the early 1990s in California, and it's grown through other states because their self-represented phenomenon there was ahead of the curve for us. But in the years since 2004, we've been trending in a similar direction to the U.S. So in addition to the research, we engaged in consultations with the courts, the bar, and other stakeholders. And in 2008, the task force issued its report in April, and the bench has accepted that report. And what it did was it led to some modifications to the Professional Conduct Handbook, which are now formalized in the BC Code. The main focus of the task force was on litigation services. They recognized that solicitors have been providing unbundled services for a long time and often without much concern, although solicitor issues were live in their mind as well. And really the central premise that they had is that for most people with a legal problem is the belief that they will be better served by getting some help from a lawyer than no help at all. And so what unbundling is a halfway option between full service representation and no representation. I want to talk a bit about 3 challenges that I see with the uptake in unbundling, but before doing that, I'm going to cover off the conflicts of interest changes that we did. And how these came about was we were approached by the pro bono community, the organized pro bono community, and they expressed a concern that had been passed on to them, particularly from larger firms that were worried about sending their lawyers to nonprofit pro bono clinics and run the risk of facing a conflict where they'd lose an existing client or be foreclosed from taking on a paying client in the future because of that representation. So we modified the conflict rules, and in a nutshell, what it means is if you are a lawyer providing pro bono services at a court-annexed clinic or a nonprofit clinic, and you become aware of a conflict, the process is to stop serving the client at that time. You refer them to another lawyer at the clinic. And rather than having that conflict imputed back to your firm, you isolate the content of the information that you've received. You don't pass it on to anyone else. And your firm can continue representing their existing client. And you basically maintain the confidences that you picked up during that consultation. Likewise, in the future, if your firm took on a client and it became aware that there was a conflict with the pro bono representation sometime in the past, you would similarly sequester that bit of information and the firm could take on the new client. So the 3 challenges that I wanted to get to are lack of empirical data about unbundling, issues with courts and processes, and marketing. And so for the first one, what I'm really getting about there is the Law Society doesn't collect data on whether lawyers provide full scope services or limited scope services. And a consequence of that is in developing changes to the handbook, we're unaware of whether they've increased the amount of unbundling that's happened, in what areas it's happened, whether it's had a neutral impact. We know self-representation has increased, so we can't even say whether the reforms have had a tampering effect on that. What I can say is I spoke with Jamie McLaren, who's a bencher now, but this was about a year and a bit ago. He's the executive director of Access Pro Bono, and what I wanted to find out was from his perception if the conflicts changes have actually had a positive impact on getting lawyer participation in pro bono at the clinics. And Mr. McLaren was of the view that yes, it has, that the unbundling changes have had an effect there, then it's been for the good. So it appears, at least from that input, that on the nonprofit sector it's making a difference, but we're really missing out as to whether it's making a difference in the for-profit sector in the marketplace. With respects to courts and processes, we consulted with the bar, and what we heard from a lot of lawyers was a concern that if they made a limited appearance before the court, would they get pulled into being on the record and having their limited service turn into a full scope service? And this is a tension essentially between their duty as an officer of the court and the freedom to contract for limited services. This was particularly going to be an issue potentially in some smaller communities where there's a sitting judge and they knew the small bar quite well. And perhaps the client speaks up in court and essentially says, well, my lawyer said this, and then the judge asks for the lawyer to come in. As it turned out, when the task force was doing its consultations, this was taking place at the same time as the reform to the civil and family rules were taking place. And all levels of court in British Columbia were quite generous with their time in talking to the task force, provided some very good feedback to them. It was quite constructive. And the task force used that opportunity to suggest to the courts that part of the reforms could involve simplified rules, forms, and processes by which lawyers could get on and off the record to speak for a limited matter in an expedited manner. Now, unfortunately, those didn't find their way into the rules, but it occurs to me that as more and more jurisdictions are asking lawyers to take on unbundling, particularly in litigation context, these discussions with the courts will probably have to come up again because the concern lawyers have about having their limited retainer turned into something larger are probably still live in many jurisdictions. The last one that I wanted to touch on is marketing and a marketing opportunity. Now, what happened when the report first came out, there's a bit of media coverage. And following that, we would get some phone calls at the Law Society. And what would invariably happen is someone would say, well, I've heard about this unbundling. I'd like to get a lawyer who does unbundling. But the Law Society doesn't track that information and doesn't serve essentially as a marketing conduit for lawyers, so we're unable to help them. And over time, it doesn't become much of a news story, not surprisingly, it's unbundling. And so it fades over time, and we stop getting those calls. Now, two of the major barriers from the access to justice perspective on potential client connecting with a lawyer, one of the major ones is people not identifying the issue that confronts them as being a legal issue. That's an education and a marketing issue to transform those perceptions. But until they make that connection, they're unlikely to contact a lawyer. For those who do make the connection, the primary barriers that you run into is actual cost of services and also perception of cost of services. Some people won't even bother because they think it's too expensive, or when they do contact the lawyer, it's too expensive. And this is where unbundling can potentially come in if you can communicate through your marketing the option that it has. In preparation for this, I did a bit of research on the internet, and what I found was that about in the first 10 pages of hits, there was only maybe a handful of firms, and they were all in Ontario, that mentioned unbundling. And when I added British Columbia to that search matrix, it got about 4 hits. 2 of those firms did, I think, an excellent job of really setting out, here's what limited scope services are, here's why we offer them, and what they can be for you. So I think until our internet search and our other searches for those types of terms show up more actual services rather than reports from law societies and articles, there will be some limitations on the uptake. Now, before we move over to Barbara, I think that we're going to have a couple poll questions that we've been running, Meredith.
We have. We first asked how many people have used limited scope retainers, and we got 50% saying they had and 50% haven't yet. And we've now asked what services do they provide, and we have only had answers on solicitors' transactional work, and that was 71%, and advocacy before a court for the client, and that was 28%. So no one's done coaching assistance for a court appearance or drafting assistance for a court appearance.
Okay, excellent. Well, that's helpful because that starts the information process, which, as indicated, has been quite lacking to date. And I think the solicitor side is consistent with what the task force had thought, that was already going on, and probably fairly smoothly. I think we're over to Barbara with some practice management.
Okay, thank you, Doug. So first I'd like to refer to the actual code definition of limited scope retainers. And then I'll talk in this part about communication with the client, the writing requirement in the code, and the main BC code provisions that are relevant in this context. So you should see a slide coming up with the definition of limited scope retainer. You'll find that in the first chapter of the BC Code, where there are many definitions of many important things. So be sure to return to that chapter for a lot of the things that you need to know when reading the rest of the code. Rules regarding limited scope retainers were added to the BC Code in September 2013 to assist lawyers and provide guidance in the delivery of these services. The BC limited scope retainer rules are based on the model code of the Federation of Law Societies, of course, like many of our rules. You may provide limited scope retainer services, of course, when you're acting either as a solicitor or as a litigator. And we saw in the poll question that it seems the majority of people are providing them in the context of acting as a solicitor. When entering into a limited scope retainer, lawyers should be aware of some particular code responsibilities regarding competence and communication. So you should see a slide coming up on competence that sets out the rule. The starting point really is competence. A lawyer acting under a limited scope retainer must perform all the legal services undertaken on the client's behalf to the standard of a competent lawyer. The same is for any retainer. However, in addition to having the requisite knowledge and skill, assess the thoroughness and preparation that's reasonably necessary to represent the client in the circumstances. Can you break this work down into discrete tasks that would work in the circumstances of a limited scope retainer? For example, would it work for you to draft a notice of civil claim? Can you do that competently? If the matter is, for example, too complicated, it may not work in the circumstances. You may better serve the client if you provide full services and even need to retain an expert. The next slide, I believe, is about communication. And you want to make sure that you don't act under a limited scope retainer if it would be unreasonable to do so, if there are unreasonable limits on you. You may need to explain that to the client. And before undertaking a limited scope retainer, you must advise the client about the nature, extent, and scope of the services that you can provide. Be clear about services you'll provide and what you will not do. It can help both you and the client if you set out the client's responsibilities in your retainer agreement as well as your own responsibilities. It's important to use very clear, plain language so that there's no misunderstanding. A written retainer agreement is quite important in the scope of providing limited services because the BC Code, in fact, requires that you communicate in writing to the client as soon as practicable what services will be provided. So if you don't do this, you not only risk having any ambiguity resolved in favor of the client on a claim, but you may be found to have fallen short of your code responsibilities as well. Be careful to avoid acting in a way that suggests to the client that you're providing full services. So for example, if your retainer is to draft a notice of civil claim, and then you start giving advice about examinations for discovery and transcripts and trial preparation and other matters, the client may think that you're going to take over providing full advice on those areas and that you're going to do it for free. This can obviously lead to a lot of confusion. So again, be very clear and set clear boundaries that both you and the client can understand. I'll talk a little bit more about retainer agreements later in the program. For now, I'm going to pass it over to Margaret.
Thank you, Barbara. I'm going to talk about the reports that we, as the Lawyers Insurance Fund, your insurer, receive. And we see claims and potential claims arising in a number of unbundling contexts. And what we realize is that in any situation in which the lawyer is providing less than full services, there are some unique liability risks, and that's what I'm going to talk about. Some of these have already been referenced by Barbara. I think we have a poll question here asking you, for those of you who are doing any unbundling or just thinking about it, what liability risks you think unbundling might create. And as you're thinking about that question, I'll start talking about what we've seen at the Lawyers Insurance Fund. First, and this is a risk that Barbara's referenced, a misunderstanding between you and your client as to who is doing what. Each month, we have about 3 lawyers who report to us because the client's expectations about the scope of the lawyer's retainer weren't properly managed. And these include reports arising in the unbundling context where there's no shared understanding between the lawyer and client as to who is doing what. I'll give you an example. A lawyer was retained to prepare a notice of civil claim on behalf of a client who wanted to sue a property insurer. The lawyer understood that the lawyer was to prepare and file the notice of civil claim, but the client would take care of serving it. The client thought the lawyer was doing everything. It isn't served in time, and the client turns and blames the lawyer. A second risk that we see is that your client really doesn't appreciate the potentially adverse consequences of choosing to limit your retainer. If you don't warn that the client's legal position or remedies or rights may be at risk and that you won't be in a position to advise them or protect them because of the limited nature of the retainer, the client is in a position that she can argue that had she been warned, she would have chosen to broaden the scope of the retainer or taken other protective steps. I'll give a few examples from our claim files that demonstrate this risk. In one, a lawyer acted for the purchaser of a piece of property that had a BC Hydro right-of-way bisecting it. The client said that he would take the right-of-way away, read it, and satisfy himself in that regard. After the purchase, the client discovers that he isn't able to access the southern tip of his property because of the hydro right-of-way and blames the lawyer. In another one, the lawyer accepted a limited retainer for the purpose of filing a tort claim in relation to a motor vehicle accident. When the client subsequently discovered that he was out of time for filing the Part 7 action, he blamed the lawyer. And the last one was a lawyer who acted for the purchaser of a small grocery business. The lawyer is hired just on a limited retainer, and the client says that she's going to deal with the lease of the premises on her own. So after the deal completes, the purchaser client discovers that the building is actually slated for demolition at the end of the current term of the lease and that she has no right to renew. She then turns to the lawyer, claiming from the lawyer the entire loss of her business investment. I'll just mention here, and some of you may know, the Ontario Court of Appeal recently considered a limited scope retainer in the case of Synergist and Lang-Michener. Now, in that case, the lawyer had acted for a purchaser, and it appears to be accepted that the purchaser was a sophisticated purchaser of a piece of property in Ottawa. The purchaser and lawyer decided that in terms of due diligence, the lawyer would deal with the traditional title issues and the client would take care of the development issues. After the purchase completed, the client discovered that there was a small strip of property that surrounded the entire piece of property that he had purchased that was actually reserved to the municipality, and it effectively blocked any access to the property. And to remove that property from the reserve so that he could have access was going to require payment of a development fee that was close to half the value of the property, so very expensive. The lawyer was sued in negligence by the client. The client succeeded at trial and then succeeded before the Court of Appeal. So that case stands for a couple of propositions about the practice of prudent lawyers. First, that a lawyer really does need to draw a bright line and clearly delineate the responsibilities of the client and the responsibilities of the lawyer. And clearly delineate really means document it so that the client appreciates the limitations on the lawyer's retainer. Now here, although the client was responsible for due diligence in respect of the development issues, the court found that the issue of access to the property was never clearly transferred from the lawyer to the client, so the lawyer maintained responsibility for it. The second proposition it stands for is that even if a client is prepared to accept responsibility for a matter, a lawyer really needs to warn about the potential consequences and risks in relation to that decision. And in this case, it would have been the importance of access to a piece of property that you're purchasing. The third risk that we see is situations where a lawyer may be parachuted in by a client to provide a discrete legal service on a bigger matter that the client is dealing with, and then finding out that because they've just been brought in on that sort of limited basis, the advice may be incomplete or wrong. Because what happens is when you're retained on that basis, you really run the risk of not qualifying the advice or assistance that you're asked to give by explaining to the client that you're basing that only on the information that the client has chosen to share with you, and that with more information, it could change. Here's an example of that risk. A lawyer was retained by a client on a limited basis. The client had been dealing with an ongoing matrimonial dispute. And the client retained the lawyer simply to prepare a separation agreement. the client gave the lawyer only the information that the client considered relevant. Before the separation agreement was finalized, the lawyer discovered that the client, the wife, actually had a judgment that she'd obtained against her husband and registered against a piece of property that had since expired because the wife didn't appreciate the need to renew a judgment. The last risk that I'll talk about is another one that Barbara's alluded to, and that's the risk of agreeing to a limited retainer when it is clearly not the right thing to do. If the matter is too complex, if the client's ability to tolerate the risk of things going sideways is very small, or if you just can't really give the advice that you need without getting more information, you want to say no. I'll talk for a moment about an area in particular where failing to get this additional information, asking the questions you need in order to get the information so that you can give the proper advice, leads to claims. And that's when you're asked by a client to just witness my signature. That's all I need done. And I'm going to come back to this a bit later, but I'll give an example. A long-standing client dropped into a lawyer's office. He brought with him a mortgage. The client told the lawyer that he knew what it was, he knew exactly what he was doing, and all he needed was to have his signature witnessed. The lawyer agreed to do that. The lawyer was later confronted by the client, who said that he thought all he was doing was guaranteeing the debt of some friends. He didn't appreciate that he was also putting his house at risk. That's an example of the lawyer acceding to the client's request to just witness my signature without asking the questions that he needed to ask to ensure that the client understood the legal consequences of what he was signing. Those limits on the retainer were limits that the lawyer probably, in hindsight, ought not to have accepted. So I'm just looking to see if we've had any responses to our poll question, but none so far. Please weigh in if you think of anything. But I'll turn now to steps you can take to try and manage these risks. First and foremost, communicate. As Barbara said, explain what you will do, explain what you won't do. As necessary, alert the client to risk. Get your client's acceptance of the limited retainer on the terms that you're proposing and the written acknowledgement that the client understands and accepts those risks. And that written acknowledgement is just part of a bigger piece of advice, which is confirm absolutely everything in writing. And for more on that, I'll turn it over to Barbara to talk a little more about retainer letters.
Oh, okay. Thank you, Margaret. We don't have another poll question now. Okay. All right. Just checking. All right. So before undertaking a limited scope retainer, we've said that a lawyer must advise the client about the nature, extent, and scope of the services that the lawyer will provide, and that the lawyer must confirm this in writing as soon as practicable. Both Margaret and I have referred to that. So a written retainer agreement can be used to fulfill the Code's writing requirement. The Practice Resources section of our website includes a sample general retainer agreement with suggestions for adapting it for a limited scope retainer. We intend that if you'd like to look at that you would amend it to suit your particular needs, style, and the circumstance. But it's a starting place, and we update that from time to time. So look for some possible new updates in 2014. We recommend that you confirm in your retainer agreement the services that you'll provide, the services that you will not provide, the tasks the client will take on, and any initial advice and warnings that are appropriate in the circumstances. For example, you may mention a limitation period that the client needs to take into account, and you may not be acting anymore when that limitation period comes due. So very important. In addition, you might consider including in the agreement the reasons for the limited retainer, a requirement that any changes to the retainer must be agreed to in writing, and of course your fees and disbursements and how they'll be charged. So a written retainer agreement will help ensure that both you and your client are clear about the terms to which you've agreed. And in the event of a claim or a complaint against you, this could assist you greatly. You should have a slide now about exceptions to this rule. It's very worthwhile to note that the writing requirement does not apply to situations where you're only providing summary advice. I think you've got the rule up there on the screen now. For example, the writing requirement does not apply if you're providing advice over a telephone hotline. I think next slide, please. Acting as duty counsel, or initial consultations that may result in the client retaining you. Okay, Margaret.
So in addition to communicate, confirm everything in writing, what else can you do? You want to take steps to help you determine whether or not it even makes sense to accept a limited retainer. And so we recommend that you meet with your client. If you can't meet with them, at least speak with them by phone. And this will help you determine what the client expects and also what the client is capable of. Because as you appreciate, a sophisticated business client has very different capacity than perhaps a first-time family law client. Also appreciate that providing services on very discrete matters, such as drafting a statement of defense, rather than on matters in which the tasks of the lawyer and the client tend to be interconnected, tend to be less risky. And here's an example that demonstrates that. A lawyer was providing limited advice on an ongoing basis to a client who was defending a claim brought against her by a neighbor for the wrongful removal of some trees. Now, it turns out that the municipality had in fact advised the client that the trees were on her property. The client later blames the lawyer when she discovers that she could have third-partied the municipality and never did that. That particular lawyer, we asked what advice the lawyer might have for colleagues to help avoid being caught in a similar situation. And here's the advice that we were given. So this is from the lawyer, I will do one-off matters on a limited retainer basis, but only where there are clear start and end parameters. And if you do decide to act, 3 more tips. First, you want to bring in any lawyers and staff in your office who might be involved in the matter so that they are aware of the limitations on the retainer. Second, if as matters are developing and unfolding, you can see that they're not playing out as you expected, deal with them right away. If you understand that your client is supposed to do X and you see that your client has not done X, that may put you at risk. And the last is another that Barbara referred to, and that's just remembering that a limited retainer is no different from a traditional retainer in terms of general risk management practices that you want to use. So, for example, you do not want to accept a limited retainer for a matter that you don't feel competent to handle. You're still going to be held to the same standard of care. Anticipate and set out the terms on which the retainer will end or you're in a position to withdraw. When your involvement is concluded, confirm it in writing. Ensure that your client's expectations of what's going to happen in the legal process and the cost involved are effectively managed. And of course, as Barbara will explain, checklists can be particularly helpful in any unbundling situation. And just before I turn it to Barbara, I should mention here that if, despite your best efforts, you make a mistake or someone says you have, remember your duty to report. The policy obligates you to report to the Lawyers Insurance Fund in writing immediately all negligence claims against you and any circumstance that could give rise to a claim however, and meritorious. And this is also an ethical obligation. And if you need to report, there's information on our website that tells you how to do that. Barbara?
Thank you, Margaret. So Margaret brought up checklists. Checklists such as the checklist in the Law Society's Practice Checklist Manual can be very helpful in dealing with limited scope retainers and determining who's responsible for doing what. It will help ensure that nothing falls through the cracks. The Practice Checklist Manual is available for free on the Law Society website, and as you may know, it's updated annually. It contains over 40 checklists lists available both in a PDF and Word, so you can edit it to your heart's content. A checklist can also help your assistant or another lawyer who may work on the file when you're away on holidays, or if you're ill, or just generally assisting you. They too need to know the limited scope and understand that, so they don't start taking on things that you were not responsible for. Some lawyers use checklists when meeting initially with a client who's interested in sharing tasks. It's a way for you to do some planning with a client as to who will do each discrete task and what those may be. You can put your initials right on the checklist next to the task as to whom will be the responsible person. So, and these responsibilities should be broken into, really discrete tasks, such as lawyer will file notice of claim in the Supreme Court of BC, Prince George Registry, rather than, painting something with a very broad brush, as Margaret referred to earlier about the confusion over who was going to actually serve a claim, and a lawyer had a problem. So, and consider giving your client a copy of the checklist. You could include it with your retainer agreement. At this point, I'd like to change the subject to representing yourself in court, communicating with opposing counsel, and communicating with the opposing party. As you know, in a limited scope retainer, a client may engage you to appear in court with respect to a particular application, but not generally. In such cases, it often happens that the lawyer doesn't go on the record and doesn't want to. These circumstances can lead to confusion about the scope of the lawyer's responsibility. The BC Code provides some guidance about how to conduct oneself when representing oneself in court and with the opposing counsel. So there should be a PowerPoint about how to conduct yourself in court, and refer to the rules. Rather than me saying the rules out loud, it's so much better having these slides. They're hard to say, these rules, they're long. So if appearing before a tribunal, you must be careful to avoid acting in a way that suggests that you're providing full services. Where the limited service to the client includes an appearance before the tribunal, you must be careful not to mislead the court as to the scope of your retainer, and consider whether disclosure of the limited nature of the retainer is required by rules of practice or the circumstances you find yourself in. And keep in mind that the word tribunal is a defined term. You see it with quotes there on the slide. The definition is in Chapter 1 and the first rule in the definition section. It's very broad, and it not only includes a court, but could conclude a board, arbitrator, mediator, administrative agency, or any kind of body that resolves disputes, even if it's a fairly informal process. And back to court, if you are not going on the record and are only making a limited appearance in court, consider your professional obligation to approve a court order if, when appearing on an application, the judge makes an order. Lawyers, as you know, generally have a duty to approve an order that was pronounced by the court when the lawyer was acting as counsel, where the order accurately reflects the court's decision. So your limited scope retainer letter should ideally include an explanation about this, that you may be in a position where you are required to approve a court order. that's something you're going to need to work out in the circumstances. You may find yourself speaking about that in court to the judge with opposing counsel and so on. And it's probably going to depend on the circumstances, but plan ahead. The next slide should set out the rules about communication with opposing counsel. Consider how you'll manage your communications with opposing counsel. Again, be careful to avoid acting in a way that suggests you're providing full services to the client. You may, however, be so far in the background that the opposing counsel won't even know that you exist. For example, if your limited retainer is that you're only confidentially assisting a client to draft a letter, you wouldn't be speaking with opposing counsel or disclosing this. If, on the other hand, you're going to appear on an application on behalf of a client, but aren't intending to accept service or go on the record, it would be courteous to let the opposing counsel know about this so opposing counsel can plan as well. The other thing to consider is your plan for communications with the opposing party. Suppose that you're not acting on a limited scope retainer, but the opposing party has counsel who's acting on a limited scope retainer. So just reverse. In this case, you can approach and communicate with the opposing party directly without the consent of the opposing party who's providing the limited scope services. And there should be a slide here, I think. Communication with the opposing party. There we go. Okay, that's the rule. So you can communicate with them, the opposing party, directly without consent of the opposing counsel unless, new slide, yeah, that's it, the opposing counsel's given you written notice of the nature of the limited services being provided and the communication that you want to make falls within the retainer's scope of the other lawyer. So where the opposing counsel has given you written notice, you're required to communicate with that lawyer, but only to the extent of the limited representation. You can communicate directly with the opposing party on a matter outside of the limited scope retainer. Margaret, I think it's your turn.
So I'll just pass on 2 tips if you've been asked not to appear in court, but to provide some drafting assistance, say, to a client. So you're not on the record and you're not otherwise visible. First, you want to be sure to alert your client to the rules around costs and the possible consequences, financial consequences in relation to costs if they do not succeed, so that you do not have an unhappy client blaming you later when they say that they hadn't appreciated that there could be adverse hits to them if an application did not succeed. And secondly, be sure to explain to your client in plain English what it is that you've done. Try and put your work product, if they're going to be referencing and using it in their words where possible, and put everything into context, because you won't be there if they're asked questions by the court and need to respond. So they need to have a handle and clearly understand what it is that you're doing. Just turning back for a moment to an issue that I'd raised earlier, which is risks around witnessing signatures, because unbundling can include just witnessing a signature. And you really need to decide whether or not in any particular circumstance that's appropriate. It may be. You may be asked just to witness a stat dec. You may act for a bank and routinely witness the signatures of the bank's representatives to mortgage discharges. So there's no issue there. But you may be asked to witness a signature and provide no more in a situation where it is clearly not appropriate. You do need to do more. And for that, I would really recommend that you read an article that's in the materials. It's called Witnessing a Signature. Stop, read this first. It will tell you how to protect yourself. And if you do decide that witnessing a signature is okay without any more, we really suggest you use the stamp "No legal advice sought or given" to protect yourself. It provides evidence of the limited nature of the retainer. You want to keep that evidence unassailable. Barbara alluded to this earlier. Do not take additional steps in relation to the matter that would belie the message from the stamp. Consider having the client initial the stamped message. And then you also want to have a second stamp or add a notice that clearly states the limited nature of the services you're providing. For instance, officer certification only. So with that, I'll turn it back now to Doug.
Thanks, Margaret. I'm going to talk a little bit now about a way of looking at an intersection between business opportunity for lawyers and the scope of legal need that exists in British Columbia. You've probably read a great deal about access to justice challenges in Canada. They're happening globally, and the question for today, to some extent, is how can limited scope retainers both be beneficial to you in your practice as a business model, but also a way of getting to address some of the access to justice challenges we face. Pardon me. I'll start with a big disclaimer. I'm going to be pulling some statistics from a variety of sources, different surveys and methodologies. Don't take it as a mathematical conclusion of certainty. I think a helpful way of looking at the stuff that I'm going to talk about now is a way of getting you into a ballpark of how to think about the scope of potential legal need and therefore the potential business opportunities that exist for you as lawyers. And I'll probably cycle back to the disclaimer a little later. So Dr. Ab Curry with the Federal Department of Justice, his principal researcher, did 3 nationwide legal needs studies in 2004, 2006, and 2008. And one of the key findings in the course of his work was that approximately 45% of Canadians will experience what he terms a justiciable problem over a 3-year period. Essentially, the way to think of that is 45% of Canadians over a 3-year period will run into a problem that has a legal element to it that could lend itself to resolution through a legal process and laws. Statistics Canada puts the population of British Columbia, age 15 and over, at about 3.9 million. So if we were to take Dr. Curry's analysis and apply it to that, it would suggest that perhaps in the neighborhood of 1.75 million British Columbians would experience a legal problem over a 3-year period. And assuming, and it's a big assumption again, equal distribution, that's about 585,000 British Columbians each year facing a justiciable problem. Now, back in 2009, as part of different research that the Law Society was doing, we commissioned Ipsos Reid to do a legal needs survey of British Columbians, pardon me, how they went about trying to solve the problems that they had, whether they used a lawyer or not, and their degree of satisfaction with that, what they might do differently in the future, what it cost them to access the lawyer, or how much was in dispute in their particular problem. And it was a sample of over 1,000 British Columbians, province-wide, across. We broke it into 3 economic strata: under $50,000 a year income, $50,000 to $100,000 a year, and $100,000 plus. And what we found was that about 70% of the people don't seek any assistance at all. 15% seek the assistance of a non-lawyer, and 15% seek the assistance of a lawyer. The 15% of a lawyer is pretty consistent with what you'll see with other legal surveys. I've seen numbers closer to 9%. I've seen some higher than 15%, but it's in, again, the general ballpark. These have different methodologies. So if we combine what we've got from Dr. Curry's studies, Statistics Canada, and what the Law Society does, what we might be able to draw from that is that each year about 585,000 British Columbians will face a legal problem. 85% of those people won't seek the help of a lawyer. So that's about 497,000 people in this province with a legal problem who won't come to you for help for a variety of reasons. And we had asked in our survey, okay, in the future, if you faced a problem, would you like the help of a lawyer? And just under 80% said they would. Now, granted, again, these are people who've been through a problem, tried to solve it on their own or ignored it, and who've come to realize the difficulty of it. And so they're looking backwards and projecting forward and suggesting, yes, I would act differently in the future. So how someone who hasn't faced a problem might act is potentially different. But that less than 80%, if we apply it to the 497,000, that would suggest that in the neighborhood of 388,000 British Columbians every year with a legal problem or at least theoretically amenable to the services of a lawyer, if there's a way to connect them to the concept of need and availability, and probably equally importantly, can they afford it? So lawyers in private practice, there's 8,316 lawyers in full-time and part-time practice in BC, and again, with a bit of a disclaimer, if you assumed an equal distribution, that would suggest that each lawyer has a theoretical potential base of an additional 47 clients. Obviously, it'll be quite different. There's geographic factors that could come into play. There's the type of area of law you practice and a range of things. In our survey, we asked people, how much did you pay for the services of your lawyer? And on average, it came to $9,524. We should note that 30% of the people who responded to this had paid less than $1,000 for the lawyer. We saw in that survey actually quite a good value from our perspective on it, because the amount that was in dispute in those matters averaged over $100,000. So the legal services were less than 10% cost relative to what was in dispute. But if we take that average cost that they paid for it and we multiply it by your 47 potential clients, that would suggest a theoretical potential of about 447,000 billables that exist out there. Now again, samples taken from different surveys, methodologies, sample sizes, people looking backwards versus forwards. The people who are looking backwards know they have a legal problem because they've been confronted with it, as opposed to not having identified it as such. And also certainly because we don't have the statistics on what services were provided on a limited scope versus full scope, we don't know of those services were those full scope retainers that led to the 9,524 average. Certainly some, if not much of it, was. And to the extent that a limited scope would lead to you providing less services, the amount is less. So again, all of that is just to suggest, it's to pull back the curtain on the concept of the scope of legal need that exists in this province and the potential value to the people who are faced with those problems. In aggregate, it runs into the tens of millions of dollars. And in aggregate, as an untapped market for lawyers, it runs into the millions, if not tens of millions of dollars. Now, we're not suggesting that unbundled legal services is the magic key that's going to solve the legal need problems of all British Columbians or instantly transform your practice to where you have an extra 50 clients and an extra $500,000 worth of billings. Far from it. But even if it's a small fraction of that, the potential benefit that you as lawyers can give to your community and to prospective clients is enormous. And at Law Society, we really think that unbundling can actually have a moderately transformative benefit for your practice as a business as well. So we think that it is both good for the courts in the extent that it takes self-representation and at least transforms it into partial representation. It is good for lawyers because it opens up business models for you that otherwise didn't exist. And we hope certainly that our rules make it more clear and give you greater guidelines for that. And from a public interest perspective, and most importantly, I would suggest, as us all being professionals, there's a benefit to our fellow citizens and members of British Columbia. I think that Barbara is going to close up with a couple of points.
And just before we do that, Barbara, I'm going to jump in. We have a question, so I'm going to read out the question, and I think Margaret's going to deal with it. So we've got someone asking, if I take on a retainer to draft an affidavit in support of an application, and I make that crystal clear in the LSR that it is all I am doing, no advice about appearing in court, etc., do I have an obligation to advise the client about costs? Why costs? What other advice is it implied that I would give in an LSR to drafting an affidavit?
Yeah, good question. What I'm saying there is that what we have seen is we have seen in the context of drafting pleadings, and I'm not actually sure if we've seen it in the context of drafting affidavits as well, or just in the context of drafting pleadings. But what will happen is that if a client has a consequence that the client did not expect, as in they go to court and they don't win and they find now there's an order against them for costs, the client is going to look for someone to blame for that. Whether or not they're successful, whether or not the lawyer has properly protected themselves and fully protected themselves so that we can defend that claim is a separate issue. It's just a tip to appreciate that an unhappy client, unaware that costs are even out there or even possible, and you're involved in the drafting of pleadings that the client is going to take and argue an application, we've seen those clients turn and look at the lawyer. So we're just saying, bulletproof yourself. If you're in that situation, it's a tip to give that client that warning.
Thanks, Margaret. So Barbara, we'll let
Sure,
you
thanks.
conclude for us.
Yeah, that's one of the warnings that could go in your retainer letter. Remember when I spoke about including warnings? That would be a good one. So we've just about reached the end of the program now, and as we've discussed, unbundling can mean many different things depending on the circumstances, and many different things in relation to claims against lawyers, as Margaret's talked about. So, and it can include just witnessing a signature. So also keep in mind that the risk can happen just as often in solicitors' work as in litigation. To assist you, in addition to reviewing the BC Code rules that you now know about for guidance, look at the materials on our website that are referred to in your course materials. Managing the Risk of a Limited Retainer, a really good article. Witnessing a Signature, Stop, Read This First, that Margaret referred to. Practice Watch, Winter 2013 Ventures Bulletin, the General Sample Retainer Agreement I mentioned, and the Law Society's Practice Checklist Manual, which contains over 40 checklists. So this concludes the formal part of our presentation, and we'd like to finish off with an invitation to you. If unbundling is to improve access to justice and help clients, it has to work for both you and the clients. So it's important for us to hear about any problems that you're experiencing, and also any tips that you'd like to share with us that we might be able to share with others. So if you have any tips to share or problems, please give me a call or send me an email. And if you have any overall policy concerns that might ultimately lead the Law Society to think about a rule change or a need for a rule change, please contact Doug. If you're unsure where your question lies, call either one of us. We don't care. We talk. And
we care.
I mean, we don't care whether it goes to him or to me. We will help and make sure your information is dealt with. So I think that's about it, and I'll turn it over to Meredith. Thank you.
And I'll just follow up on your point that you want to have more information from everybody. So when I posted the poll question for Doug earlier, I didn't give everyone a chance to make multiple selections. Oh. So our answers were not complete. So I have reposted the question, and I do hope people will answer it. We'll leave it up even after the course, and I will give those numbers to Doug, who's very interested to know what you are all doing with limited scope retainers. So that is the end of the program. That's all the time we've had. It's not given us time for question and answer period, but I would encourage any of you who have questions to contact Doug, Barbara, or Margaret at the Law Society, and their contact information is available on our materials page, or of course you can always find them on the Law Society website. They are very interested in hearing from you about any of this, I've been told. So thank you. Thank you very much to Margaret George, Barbara Buchanan, and Doug Monroe. They did a lot of work to prepare this presentation for you, and we are very appreciative of all the effort that they have made. We'd also like to thank all of you very much who have participated with us here today. We would like your feedback on the program, and as an incentive to have you fill out the evaluation that we will be sending later today by email, we will enter your name in a draw if you give us your contact information in a draw for a $100 gift card from Future Shop or a future CLE-TV program, and we do 3 draws per year, 1 per term. If you have ideas for future presentations on CLE-TV, please contact me, Meredith Woods, at CLEBC, and thank you very much for being here. We look forward to seeing you here again soon.